and welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we apprise you with the recent important legal developments across the country. Here are the headlines. Day 13 of the Supreme Court hearing pleas challenging the abrogation of Article 370. Supreme Court website falls prey to phishing attacks. Supreme Court refuses to entertain petition challenging 100% reservation in medical colleges for local candidates in competent authority quota in Telangana. Supreme Court resumes hearing pleas challenging remission to convicts in the Bilkis Bano case. SCBA condemns Lathi Charge by police in Hapur, seeks investigation in the case. Now let's take a detailed look at the headlines. A 5-judge constitution bench of the Supreme Court, comprising the Chief Justice of India D.Y. Chandrachud, along with Justice S.K. Kaul, Justice Sanjeev Khanna, Justice B.R. Gavai and Justice Suryakant, heard the pleas challenging the abrogation of Article 370 for the 13th day today. The hearing in the matter began on August 2nd, and so far the arguments of the petitioners have been heard by the Apex Court, and presently the Attorney General and the Solicitor General are appearing for the Union of India. On the last date of hearing, the Apex Court dealt with the question whether Article 370 could have been amended by taking the route through Article 367. Article 367 provides with interpretation clauses within the Constitution of India. And by way of Constitutional Order 272, which was issued by the President of India on August 5, 2019, the definition of the Constituent Assembly of Jammu and Kashmir was amended to mean the Legislative Assembly of Jammu and Kashmir. The petitioners have argued in this regard that by allowing this action, it would mean that the executive would be able to change the meaning of the words by way of a simple amendment, and the process for amendment as prescribed under Article 368, which requires the ratification by majority of state assemblies, will be defeated. The CJI in this regard questioned the Solicitor General Tushar Mehta, appearing for the Union of India. He said, if Article 370 could be altered by a process other than that prescribed under Article 370 Clause 3, SG Mehta submitted before the bench that in the absence of a constituent assembly, Article 370 Clause 3 could never come into effect, and Article 370 would get the status of a permanent provision, and therefore Article 370 has been modified by way of the mechanism provided under Article 367. Today, the Solicitor General highlighted how the abrogation of Article 370 has proved to be fruitful and informed the court that terrorist instances have reduced by 45.2% compared from 2018 to 2023. Infiltration reduced by 90%. Law and order issues like stone pelting, etc. reduced by 97%. Security persons casualties have been reduced by 65%. And there have not been any burns in the Jammu and Kashmir ever since the removal of Article 370. He also highlighted that several initiatives are being taken by the Centre for the Development of the area. And at present, investments stand at Rs 2153 crores in the erstwhile state. Several e-initiatives have also taken place, the SG told the court today. On this, Senior Advocate Kapil Sibbal, appearing for the petitioners, said that if you have 5,000 people in house arrest and with Section 144 imposed, there cannot be any band. Attorney General of India R. Venkatramani also presented his arguments before the court today and said that there is a void, there is an impossibility of complying with the proviso of Clause 3. And how to tackle that void? The President could have said that without taking recourse to any other action, I could myself render 370 inoperative. But the President does not adopt that course. The AG further said that there is only one solitary interpretation, that is to aid the constitutional integration process. If any deviation occurs, it is open to correction by the President. It is open to the President to take stock of all exercises undertaken under Article 379 and take into account the larger considerations that loom large before the nation, particularly before Jammu and Kashmir. The website of the Supreme Court of India today fell prey to phishing attacks after the perpetrators made a fake website impersonating the official website of the Apex Court. The Registry of the Supreme Court today issued a notice advising the public at large to not click or share links without verifying the authenticity of the same. The registry also informed that the Supreme Court of India does not ever ask for personal, financial or confidential information, and so the same shall not be shared, as it could be the website impersonating the apex court. The registry has advised the victims to change their passwords and contact their banks in case of unauthorized access. Law enforcement agencies have also been informed in this regard, and appropriate action will be taken, the notice by the registry mentioned. A bench of Justice P.S. Narasimha and Justice S.V.N. Bhatti of the Supreme Court today refused to entertain a petition challenging the 100% reservation for local candidates in medical colleges of Telangana in the competent authority quota. The state government of Telangana passed an order on July 3rd this year, reserving all competent authority quota seats in medical colleges established after the formation of Telangana in 2014 for local candidates domiciled in the state. The state has contended that the move will enable the students hailing from Telangana to be enrolled in a local medical college within their state. The petitioners, students from neighbouring state of Andhra Pradesh, have however challenged the admission policy as illegal, arbitrary and violative of fundamental rights guaranteed under Articles 14, 16 and 21 of the Constitution of India. The petitioners also submitted that such policy is also in violation of Section 95 and other provisions of the Andhra Pradesh Reorganization Act of 2014. The Supreme Court refused to hear the plea, stating that a similar petition is pending before the Telangana High Court for adjudication. The top court also expressed displeasure over the petitioners trying to institute parallel proceedings. A bench of Justice B.V. Nagaratna and Ujjal Bhuyan resumed the hearing of batch of pleas challenging the grant of remission to 11 convicts in the Bilkis Bano case. The case relates to the gang rape and murder of 7 family members of Bilkis Bano during the 2002 Gujarat riots. The convicts in the case were released by the Gujarat government on the basis of the 1992 remission policy, when the new policy in this regard was adopted in 2014. According to the 2014 policy, the state is not empowered to grant remission to persons convicted of offences of murder with rape or gang rape. Advocate Rishi Malhotra, appearing for one of the convicts, told the bench that his client has already served over 15 years sentence and the state government gave him the relief on the basis of his good conduct. The apex court has been hearing the case for several days, and on August 24th, it expressed surprise over one of the convicts practicing law after serving his sentence. The top court had remarked that law is supposed to be a noble profession. The Supreme Court Bar Association condemned the recent incident of Lathi Charge by the Uttar Pradesh police on advocates in Hapur district and urged the state government to investigate the incident and punish the officers found guilty in the matter. The SCBA called the incident inhumane, as women advocates were also not spared from police brutality. A resolution passed by the SCBA stated that the Lathi Charge on the advocates who were protesting peacefully against the alleged high-handedness of the police is a clear violation of their rights and the rule of law. SCBA expressed solidarity with the lawyers who were victims of the police brutality and urged the state government to probe the matter and compensate those injured in the matter. The incident took place when the Hapur Bar Association officials were staging a protest on August 29 over a fabricated case filed against a female lawyer and her father. The tension escalated when the police resorted to Lathi Charge on the lawyers and injured several of them. That was all on today's legal news. Thank you and keep watching Verdictum, and subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.